Hey guys, in the Alex Murdaugh case, we have some news. The state was supposed to respond today to his motion for he wanted to suspend his appeal and then be able to file a motion for new trial based on what he says were inappropriate communications between the clerk and a jury. You've heard all about that. If those things are true, that's terrible. The state has responded, and maybe a little surprising. Let's take a look at it together. So here it is. It's very short. And I did glance through it. So what you're going to see is basically the state saying there's a procedural defect and Murdaugh needs to cure it. But if he does, they kind of don't contest the fact that there should be an evidentiary hearing, that the appeal should be suspended, and this matter sent back down to be heard whether there was misconduct or not. Of course, they want Judge Newman to do that. I would expect Murdaugh might argue about that. He gets to file a reply to this within 5 days. All right. So anyway, they go through what's going on, which we already know is that Murdaugh filed his paper saying that there were, how they put it, a blend of mixed allegations broadly directed at the Colleton County Clerk of Court, Rebecca Hill. And they cite some of the procedural things. And of course, the fact that you shouldn't do this lightly because you can always dredge up some minor thing as a reason to get a new case. Harpootlian kind of admitted that too, as he said, but the things they're alleging are not minor. Here they're saying to prevail on this request, he has to have the evidence in question as such will probably change results if a new trial is granted. It's been discovered since the trial. The evidence could not have been discovered prior to the trial by exercise of due diligence and is material to the issue of guilt or innocence. It's not merely cumulative or impeaching. And some of that's a little different, though, when you have a state actor who's interfering. I think Murdaugh has some good cases for that, and the state kind of concedes that later. So here they do say something which is important, though, that the movement must show that he did not know of the existence of such evidence at the time of the trial and that he used due diligence to discover such evidence. And he couldn't have discovered it by the exercise of due diligence. And you have to make a prima facie showing of these factors before remand to circuit court. Then they cite a case saying that, sweeping all the way back to 1896. Anyway, it is essential to the consideration of a motion for a new trial based on after discovered evidence that such motion shall be supported by an affidavit of the accused himself. And I didn't see that in the motion that was made. I saw all the other affidavits they had. Unless a valid and sufficient reason for the omission to file such an affidavit is shown, the affidavit of the accused must show that he did not know of the existence of such evidence at the time of the trial, and he used due diligence to discover it, or couldn't have discovered it if he had exercised due diligence. An affidavit of his counsel showing these matters is not sufficient. Now, of course, assuming that Murdaugh didn't know about this stuff, then he could file an affidavit. Now, look at what the state says here. This is important. It may well be that suspension of the appeal and a remand for an evidentiary hearing will be necessary to properly resolve some of the serious claims raised by appellant in the motion he intends to file. So they're kind of conceding that this stuff is in the magnitude that an evidentiary hearing would be the appropriate remedy. Now, they do say investigation by SLED is ongoing, and there are significant factual disputes as to the claims in appellant's motion. But factual dispute is not really for the Court of Appeals to resolve at this level. The issue is whether Murdaugh has raised enough issues that a judge should look at it. And I certainly think so. All of the lawyers that I've been talking to online think so. And even the state here appears to agree with that as long as the predicates to the motion are made. They say if there's no credible evidence to be found to support the claims brought by Murdaugh, the state will be prepared to argue against the motion before the Honorable Clifton B. Newman on remand. So in other words, they're saying, we'll have this argument on evidentiary remand if this thing is properly presented to the Court of Appeals. It's pretty much a concession there that not that this happened, but that the issue is raised well enough that it should be addressed. But they say at present it is procedurally defective, because what they have does not reveal precisely when or how Murdaugh learned of the claims he now raises, nor has he provided the affidavit required. And then they talk about what Harpootlian and the other attorneys said during press conferences and other things, that we saw things and stuff like that. But I think that's pretty thin. They didn't know about the clerk's statements until they were told about them later. I think that's fair to say. It does say that they were warned that things that happened in the jury room that were bad, but they also both said in those interviews, we tried to talk to people, but we were met with a cone of silence, I think is what they said, Griffin said. So they're going to be able to say, look, we tried to find out what was going on, if there's anything to it. And it wasn't until this book came out that we learned about it. In fact, that is what they said when they were talking. But they, according to what the state is saying, they need Murdaugh himself to file an affidavit saying, hey, I didn't know about it either. In fact, I didn't learn about it until August, similar to my attorneys. That's what the state is asking for here. So they say the state is compelled to move to dismiss due to the procedural defect. Okay. The state would request the court grant Murdaugh leave of 10 days to correct it, right? So they're even saying here, don't just throw this thing in a garbage can, give him 10 days to correct it and establish precisely when and how it is he first learned of these allegations. So I haven't gone back and read these cases yet, but assuming that this is essentially correct, you can expect Murdaugh's team to fix that, maybe even in the reply that is due within 5 days, unless they intend to dispute whether it's necessary or not. But even if they're wrong, the state is saying, nevertheless, let him fix it. So it doesn't look like this will be dealt with in any kind of summary fashion. Instead, it looks like all people think this likely needs to head back to an evidentiary hearing. I think the point of disagreement will ultimately be whether it should be in front of Judge Newman or some other judge. So that's it. As you can see, that's the whole thing. All right. Well, that is it. Thanks. Bye.